Okay, they gave me the thumbs up. Good evening, everyone. How are you tonight? My name is Michael Lee, and I'm the president here at the Museum of Chinese in America, where our mission is to preserve, illuminate, and celebrate the rich history and contributions of Chinese in America. By fostering understanding and greater recognition of our experiences, we endeavor to inspire and connect all Americans. I want to welcome everyone tonight to a continuation of MoCA's legal series, where we highlight how cases involving Chinese Americans have impacted the U.S. legal system. And I'd like to thank our sponsors for tonight, Barclay Damon, for making these talks possible. It is my great honor to introduce Professor Thomas Lee. Professor Lee was born in Seoul, Korea, and immigrated to the United States in 1974. He went on to study at Harvard University, where he received his A.B. summa cum laude, his A.M., and his J.D., and served as Articles Chair of the Harvard Law Review. He is also an ABD for his PhD in government at Harvard. Before beginning his career in academia, Professor Lee clerked for Judge Michael Boudin and Justice David Souter of the United States Supreme Court. He also served our country as a U.S. Naval Cryptology Officer in Korea, Japan, Washington, D.C., and at sea. Today, Professor Lee is the Leitner Family Professor of International Law at Fordham University School of Law and co-director of the Center on Asian Americans and the Law. Founded in 2022 by Professor Lee and Judge Denny Chin, who many of you recall spoke here at MoCA last July, the Center on Asian Americans and the Law is the first of its kind in the nation. It is dedicated to educating students, scholars, and the public about Asian American legal history, and to advance advocacy on issues such as anti-Asian violence, immigration, citizenship, affirmative action, employment barriers, such as the bamboo ceiling, and the enduring myth of the model minority. This evening, Professor Lee will guide us through the landmark Supreme Court case of United States versus Wong Kim Ark. Decided in 1898, this ruling enshrined the principle of birthright citizenship for all children born on U.S. soil, regardless of ancestry or parental nationality. More than a century later, that decision remains at the heart of national debates. As recently as this year, presidential executive actions have sought to challenge that principle, making the case of Wong Kim Ark as urgent and relevant as ever. At a time when the very right of Asians and other immigrants to belong in this country is still being questioned, it's vital to understand the legal foundations that have shaped and defined American identity for generations. So we're so deeply grateful to have Professor Lee with us tonight to share his insights. Please join me in giving a warm and enthusiastic welcome to Professor Thomas Lee.
The Constitution was signed in Philadelphia. It also happens to be Justice David Souter's birthday. He passed away in May, and I sort of have a weird disconnect today because this morning I was in Washington, D.C., the Heritage Foundation. You might have heard that, but they published a guide on the Constitution, a third edition, and they collected 200 or so essays, and I contributed one of the essays about the Admiralty Clause. So today's been sort of a weird Constitution Day from the Heritage Foundation. I took the train up, and now I'm at the Museum of Chinese in America talking about Wong Kim Ark. And what I'm going to try to do is, it's a complicated issue, and it's a complicated case, but I'm going to try to explain it to a non-legal audience and see why it's so important and kind of get a nuanced understanding of it. The framing is, and this was why the morning at the Heritage Foundation is relevant, we have a Supreme Court that is originalist in its constitutional interpretation methodology. There's 5 justices that are clearly originalist, one who appreciates history, Chief Justice Roberts values precedent more than the other 5. And so in order for them to decide, the Supreme Court to decide the constitutionality of the executive order regarding birthright citizenship, it's going to be important to understand the context of the enactment of the Citizenship Clause and the Wong Kim Ark case. So there's going to be a lot of history that's going on. And my prediction is that the Supreme Court will decide the case by June of 2026. So we're probably going to have a decision by the court. And so what I'm going to try to do in the time is to sort of set up the executive order and set up the case and help you understand what's going on exactly. So the crucial provision is something called the Citizenship Clause of the 14th Amendment. And it's in the 14th Amendment, Section 1, Clause 1. And it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And so I've underlined the critical parts of that particular provision, and it was ratified in 1868, right? And so the Supreme Court would have cause to decide this particular meaning with respect to Wong Kim Ark 30 years later in Wong Kim Ark. So we're going to talk about that case, but I just want you to have a look at the words, and the critical language really is, what does it mean to be subject to the jurisdiction of the United States? And as I can fairly say, no one knows for sure. That's the crux of the debate. So you have sort of the majority view is subject to the jurisdiction just means subject to the territorial jurisdiction. So if you're born in the United States, that's all that means. There's a minority view that says subject to the jurisdiction implies some greater degree of political allegiance, subject to the political jurisdiction, right? And so that's the interpretive question, the debates that are going on with respect to that provision. So on January 20th, President Trump issued an executive order interpreting the Citizenship Clause to authorize the executive branch to deny recognition of American citizenship to children born in the United States whose fathers are not U.S. citizens or green card holders and whose mothers are unlawfully or temporarily present in the United States. That's what the executive order says, right? And so unlawfully present, undocumented, entered without the approval of U.S. federal immigration authorities, or temporarily, you were here on a tourist visa or perhaps overstayed, or a student non-immigrant visa status. So that's what the order purports to do. And I'm going to toggle back to the Constitution because the puzzle is, do those two categories of persons, I mean, clearly they were born in the United States, so it turns to, do they fit within the understanding of subject to the jurisdiction as those words are understood in 1868, because we have a majority originalist court, and so that's the interpretive puzzle that's being presented by this particular case. So before I talk about Wong Kim Ark, I just wanted to do a little bit of prehistory, and it was Michael had gave me a quick tour of some of the museum, and one of the exhibits talks about some of the legislation that had been passed with respect to Chinese, and I didn't see the act to prohibit the coolie trade of 1862. Might have been higher up. Okay. So that's a very interesting statute. So it was sort of the John the Baptist, the predecessor version of the Exclusion Act. So during the Civil War, there was this fear that perhaps the Chinese coolies, coerced indentured laborers, would be brought in to substitute for plantation labor. And so Congress, the Union, passed this statute. And then the second act was the Page Act of 1875, excluded Chinese women and coerced laborers. And that was a very calculated measure. Part of what was behind the Page Act was the perception that Chinese women were sex workers, but also there was a very real instinct that they didn't want Chinese to settle in the United States, right? And so that was the first of the statutes. And the third one, the most famous one, we call it the Chinese Exclusion Act. It was actually called an act to execute certain treaty stipulations relating to the Chinese. And it was titled that way because there was a legal debate, because at the time, the U.S.-China treaty had allowed free commerce and travel with regards to the nationals of both countries. And so there was a debate, and there was concerns that from a legal perspective, if they were to exclude Chinese laborers, they would be in violation of the Burlingame Treaty, the treaty that was then valid. So they passed this statute, and it purported to exclude laborers who were not in the United States at the time of the enactment of the statute. And so the way to prove that was you had to have a certificate of residence that basically you had been in the country as a laborer prior to the enactment of that statute. So if you were a merchant, if you were a student, if you were a teacher, if you were a tourist, the statute did not apply to you. It was only for laborers, and it was kind of a complicated story. Sort of working class interests in California that had pushed for this. The Scott Act of so what happened was the numbers of Chinese coming into the country continued, and many of the people in the United States, there were very few Chinese women. The laborers would go back to China and come back, and they'd have these residence certificates. And so the Scott Act prohibited reentry, and then the Geary Act. So successively, you see a tightening of the Exclusion Acts, and then the Chinese exclusion. They were 10-year terms, but the Exclusion Act of 1902 made the exclusion of Chinese laborers permanent. And it wasn't until 1943 when they repealed the Exclusion Act, when China was an ally of the United States during the Second World War. Why is this relevant to Wong Kim Ark? Well, you're not actually, because of the Exclusion Acts, the numbers of Chinese in the United States at the time that Wong Kim Ark was decided in 1898 was relatively small. The numbers had been going down, and so we're talking about a relatively small population, right? So this is the, remember I said the Exclusion Act was actually called the Act to execute certain treaty stipulations related to Chinese. So this is the actual cursive version of that, the first of the Exclusion Acts. And that's what it says. And they used suspended because, again, they didn't want to break the treaty. They weren't sure that a statute could break the treaty, so they used the language of suspended. Classic lawyer moves, right? But in any event, that's the first of the Exclusion Acts, and so this is an example of the certificates of residence that you're required to have to come in. And in the museum, you've got a number of samples of this. There's a lot of counterfeiting going on, and that's actually a part of the subtext out there. We don't know the numbers, but certainly everyone thought that the Chinese had lots of counterfeit certificates, right? And I'll show you some of the interesting things later on. This is another certificate. So here's some population figures. So if you see the exclusion, so you see the numbers drop precipitously as the immigration in the prior decade, as the Exclusion Acts kick in, and the population starts dipping, right? And so if Wong Kim Ark is decided in 1898, I mean, I think that it's a good estimate that the population of Chinese Americans is probably right around 120,000. Now, historians, when they estimate the number of people reported in the census that were actually born in the United States, I've seen 10 or 11%. So when you ask yourself how many people were in Wong Kim Ark's situation, someone who was born in the United States to Chinese parents, we're talking maybe several thousand tops, right? I mean, it's a relatively small number. And so that's something to be aware of. The number dips precipitously, and you can see how immigration really slows down to a trickle, and then it picks up again right after the Chinese Communist Revolution. But in any event, that's relevant. So this is Wong Kim Ark. He was born in California in, I think 1873, I can't remember exactly, 1873 or 1872, and his parents had come from China, and they had been living in San Francisco, and he went back to China when he was 17 in 1890, and then he went back again in 1894, and when he was coming back, at that point, they had discontinued, the Geary Act had dropped, so he wasn't allowed to come back in using a certificate of reentry, but he claimed that he had been born in the United States and therefore entitled to citizenship, so that was the posture of the litigation. So he said, like, look, I don't need a certificate of reentry because I am a citizen born in the United States, and he relied on the language of the Citizenship Clause, right? I mean, the Citizenship Clause says born in the United States and subject to the jurisdiction thereof. Now, his parents had not naturalized to become U.S. citizens. In fact, they were not allowed to, because under the naturalization statute at the time, you had to be a free white person or a person of African ancestry or descent. And so his parents were not allowed to naturalize. And so, but he was born in California. And so the question in Wong Kim Ark is, well, when you look at the Citizenship Clause, is he a citizen of the United States by operation of the Citizenship Clause? And that's exactly how the Supreme Court presented the question. The question presented by the record is whether a child born in the United States of parents of Chinese descent, who at the time of his birth are subjects of the Emperor of China. The 18th and 19th century Americans put a lot of stock in the distinction between the words subject and citizen, because the idea was that a citizen was a member of a republican community and a subject was the subject of an emperor or a king. And so you see the word subject to the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business and are not employed in any diplomatic or official capacity, becomes at the time of his birth a citizen of the United States by virtue of the Citizenship Clause, right? And so you can see that he actually had a permanent domicile and residence. The parents did. And so the Supreme Court answered the question yes. And they answered the question yes by looking at sort of a variety of sources from the common law English tradition saying that basically if you were born in the territory of the British Crown, you were a subject of the British Empire and so forth. But notice there's some ambiguity as to how, if the answer to that question is yes, there's some ambiguity as to how it applies to the current executive order. Because number one, what about people who are temporarily here? Domicile means that you're at a place, you live there with the intention of making it your home. So obviously, if you're a temporary sojourner, then you can make an argument that you don't have domicile in the United States. The other question is, presumably, they have domicile, but they entered the United States lawfully. And so could you make the argument that even if you're at home in the United States, if you entered unlawfully, then Wong Kim Ark doesn't apply? Now, if you're an originalist, like a hardcore originalist, and Justice Thomas has said this, you don't care about Wong Kim Ark, right? You just care about the 1868 original meaning. It so happens that the Wong Kim Ark opinion was pretty close to the Citizenship Clause's ratification, 30 days, and so you might care more than you usually would, but you're really looking at the original meaning of the provision in 1868, right? And so but in any event, you could make the argument that, look, his parents were lawfully domiciled in California, and so whatever the holding of Wong Kim Ark, it doesn't apply to a situation if someone has come here in violation of federal immigration laws. Now, this is where things get a little bit interesting, and I've been conducting research on this. This was a travel document he tried to use to come back in. This is a New York Times or Washington Post article about the holding. Now, so I told you, so a lot of people think of Wong Kim Ark and they say, well, it's an amazing holding, sort of a triumphalist narrative of a pro-citizen, pro-Chinese. I mean, it's surprising that Chinese Americans won this case. But if you think about it, and this sentence is from the opinion, to hold that the 14th Amendment of the Constitution excludes from citizenship the children born in the United States of citizens or subjects of other countries would be to deny citizenship to thousands of persons of English, Scotch, Irish, German, or other European parentage who have always been considered and treated as citizens of the United States. And in 1900, there were 1.6 million persons born in Ireland, almost 500,000 persons born in Italy, 425 born in Russia by comparison to the 119,000 China, and the percentage of that population that had children born in the United States was much higher than 10%. And so you're talking about a holding that really has much more impact for all of the Europeans rather than the handful of Chinese that are in the country, right? And so in some sense, it was Wong Kim Ark that litigated the case, but it wasn't necessarily the Chinese that benefited because the holding didn't say that the Exclusion Acts were unconstitutional. It didn't say that the naturalization statute that said that you had to be a free white person or a person of African descent were the only ones who could naturalize, right? It didn't change all of that. And so part of understanding the case better sort of understands it was a victory for Chinese Americans, but to some extent, it wasn't a complete victory. It was a Pyrrhic victory, and it sort of implicitly recognized race-based restrictions on the Exclusion Acts and in the naturalization context. So in any event, that's point one. The other point is, and these are
he would go back. I mean, it's great to see these pictures. He's aging. Um, I think that's him. That's him from presumably that's the 1894. So he's 20. And then in this shot, that's him. I believe this is 1913. Yeah, there it is. So this is him at 20, I guess about 39, right? And that's him 18 years after that. So 39 plus 18. He's my age. Do I look? I think I do look a little bit younger than him. I hope, right? Um, no, it says he's 62. Okay, so he's a bit older. But in any event, um, so the one detail that I was telling you about is a lot. There's a great deal of suspicion that many of the Chinese who were in the United States had entered with fake paper, had bought paper. What is the scale of it? I've been digging into it. It's really hard to figure it out. But there was something called the Chinese Confession Program, which was started in the San Francisco district office at the INS, and it allowed Chinese immigrants who confessed to having entered the country fraudulently to obtain legal status. And from 1957 to 65, when the program was ended, 11,336 people confessed to legal status. 19,125 were named by confessors as illegal, and 8,031 fraudulent slots. So I've discovered all these cases, particularly from 1921 to 1924 in Hawaii. Like you'll find like 9 people with the same name coming in, right? And so how is this relevant? Well, everyone kind of suspected that a lot of the Chinese had come in unlawfully, but I haven't seen any instances in which they tried to take the citizenship, or they made the claim that the child of the people who had entered unlawfully was not a citizen, right? Now it's hard for lawyers to prove something by a negative, right? And so I do believe that in general, it gives us the sense that it didn't really matter if you had come into the country unlawfully. Once you were here, if your home was here and you had a child here, people at the time seemed to have understood that you obtained citizenship by birth, regardless of what your parents had done to come to the United States to make a home here. The temporary visitor piece is really, really interesting. And I'm in the process. I'm writing an article. I'm actually presenting it to my faculty tomorrow. My guess, I mean, just based on the evidence, my best estimate is they thought that if you were in the United States, there's evidence both ways. And generally there's a case involving an Irish niece of a American uncle who died without an heir, is giving land, and at the time that she was born in the United States, her father, who was the brother of the rich uncle, had thought about living in the United States and then gave up after she was born. There are those kinds of facts. And that would seem to suggest that even if you're temporarily here, you're born here, you have citizenship. But there's a great deal of anti-Chinese sentiment, right? And there's a great deal of anti-Chinese sentiment even in 1868, and this was before the Page Act was coming in. So ironically, I happen to think that based on that if you're really looking at the best estimate of the original meaning in 1868, and they were thinking of the Chinese, and they were thinking of Chinese who would have children and then probably go back, I mean, there might be a good argument that they weren't included, right? And so it's interesting to think about that. There's evidence on both sides, but that's something that I'm working on. The last thing I'll say is the United States is really an outlier in terms of countries in which citizenship is granted solely based on birth in the country. It is a minority jurisdiction. The light blue is the only countries without restriction. Even among them, the United States is extreme. I think most of these countries, like the idea that if you're just born here and you're only here for 30 days, in some cases the child gets citizenship, that is an extreme outlier position on birthright citizenship. And so that's just an interesting detail. I mean, in today's world of very easy transportation, it's interesting to think about that. But anyways, we'll see what the Supreme Court thinks, right? Fascinating case. Wong Kim Ark stayed in the United States. He had sons. He moved around. He spent certain bit of time in all places in Texas, in El Paso, and he was sort of hassled by border inspectors crossing over through Texas. I guess they hadn't heard of the Supreme Court case, and he had sons. That's another interesting issue, because if you were a citizen like Wong Kim Ark by birth, and then you had a child in China, then under then laws, the child was entitled to derivative citizenship. And there's a lot of litigation involving those kinds of cases. And again, the sense that there was a fair amount of counterfeit paper out there as well, right? And so it's interesting to follow these leads. But the bottom line, as I sit here at this museum, as I look at you, as I look at all the wonderful exhibits, it's remarkable to me as a legal scholar, as a legal historian, to realize how important this history is. I mean, and that understanding it correctly has takeaways, like immense takeaways for current constitutional litigation that is active at the court. So with that's my presentation. So I don't know if
Court, which shot down Trump's executive actions. How will that hold?
Yeah.
And obviously, the Supreme Court's going to look at it next year anyway. So.
Yeah. So there are 7 different lawsuits, right? So in the Trump versus Casa case, the Supreme Court said they didn't rule on the merits of this at all, but they said that one district court can't issue an injunction stopping the government from enforcing it everywhere. And then after that, some litigants filed for a class action lawsuit. A class action lawsuit means that technically you do represent everybody similarly situated in New Hampshire, and that was granted, right? So that was just argued at the First Circuit, and the First Circuit, which is the federal appellate court for Massachusetts, Rhode Island, New Hampshire, and Puerto Rico, pretty strongly indicated that they're going to strike down the executive order across the board, both unlawful and temporary. The Ninth Circuit, which is the circuit court for Washington State, Hawaii, California, Arizona, a couple other states like the western states, they have a case involving some states and some individual litigants, and they've also said that the executive order is unconstitutional, right? Now, the reality is, regardless of what the lower courts say, it's ultimately going to come down to what the Supreme Court says, right? And so the fact that the plaintiffs have won in those 2 lower court litigations doesn't necessarily mean that they're going to win at the Supreme Court, right? But I do believe, as I was saying to you today, like my own, as a legal historian, I think that the evidence seems to indicate that if you have made a home in the United States, it doesn't matter whether your parents came here unlawfully, right? I mean, the Citizenship Clause probably protects you. So my guess would be, even from an originalist perspective, that part would probably be safe. Now, this is something I tell my students. I think that what happens a lot of times is when you're so convinced that you're correct, you don't think about your arguments critically enough, right? And so if you go up against a court that doesn't share your sort of priors or your presumptions or how you assume the world to work, you may lose, right? So I think it's extremely important to keep an open mind and to sort of think about these issues in a way that is aware of the other side's arguments. And that's something that, as a law professor, we try to teach our students to do that all the time, right? But the current posture is, in both of the lower courts, the government has lost effectively. Yes, sir.
Hi there. Wonderful presentation. My question is about statistics. What is the estimate? How many person born in the United States that might be are not citizen now?
Right. So
that's passed.
Right. So I think if you include the undocumented category, right? I don't know. We're talking probably at least a couple million. That's a huge category, right? So the temporary category, so the last time I looked at it, like so-called birth tourism, where I don't know if you guys saw the article in the Times about the places in Queens where they sort of The numbers I've seen are like maybe 30 or 40,000. I had a student who talked, who actually recently wrote a paper for me and Judge Chin about wealthy Chinese who pay for surrogates in the United States, and how this all works out for them, right? But I think that number's a lot smaller. Now, there's problems with the at-home test. So let's say you're foreign students, you come to the United States on student visas, but you're in graduate programs, so you're in the United States on visas that allow you to stay here for 3 years. You know, you really want to stay. You have a kid, right? I mean, are you at home here or not? I mean, when you have an at-home test, it necessarily turns to a great extent on subjective intent. And so that creates a lot of complexity. So I'm sure there's tens of thousands of cases like that, foreign graduate students. Technically, they're here on a student status, but they really want to stay, right? I mean, and so my view is that under those circumstances, then you probably do have the requisite intent, because the idea is to say that you only are a citizen if your parents are citizens. That's almost too much. That's requiring too much allegiance. To say you're a citizen just because one of my students told me a story about a woman who was coming from Taiwan, and she went into labor on the Trans-Pacific flight, and they were going to land the plane because they hadn't crossed the date line yet, and she insisted on making it to U.S. territory. But that seems too thin. But I mean, I think that in many instances, people come here on temporary. So I think that the visa status is a presumption, and that's one place to start. But I do admit that if you go and believe that, then it introduces a lot of subjectivity and ambiguity in how to figure this out, right? Yes, sir. Yeah.
I'm not sure that parental status is that important. I think or parental citizenship, rather, is important. I think it's the status. It's having a green card or having permission to migrate. I think that's the important of the importance of the subject to the jurisdiction of.
Mm-hmm.
It's the illegal, non-vetted immigrants that I think are at risk.
Yeah, I mean, but the contrary interpretation is subject to the jurisdiction thereof just means that you're under the sovereign control of the United States. So
Yeah.
even if you're here in undocumented status, like if you break the laws, like you could go to jail and you have to follow the laws, right? So that's the interpretation of subject to the jurisdiction that says that, look, even if you're here in an undocumented status, you're subject to the jurisdiction.
I think as long as you have some status
Yeah.
granted
Yeah.
appropriately, I think you're okay.
But what
even
if you
and then there's the exemption of diplomats.
So what if you had a tourist visa and you overextended it by 7 years?
Well, I think that's not a.
Yeah.
It's
So-
not an exactly because unless you accept tourist. What is that term? Birth tourism. Yes. I mean,
But
I don't think that's an
the
accepted.
problem of coming in on a 90-day tourist visa and staying for 7 years, that's different, right? I mean, that kind of feels more like you're undocumented.
Yeah.
Yeah.
Because there's some illegality in that.
Yeah. And based on my thinking or the evidence, I think that they didn't really think that the Citizenship Clause, the understanding of subject to the jurisdiction, the fact that the parents behaved unlawfully, sort of somehow, diminished the automatic effect of this clause. It's just what I'm seeing.
Well,
but that's what the government is arguing.
And,
right?
and while the 14th Amendment was purely intended, I think, for African Americans who were freed by the Civil War. And
but the words don't say that, right?
but that was the intent. If you
Yeah,
go
yeah.
and look at the research,
Yeah.
and I think that's what, if you want to do original intent.
That's that's a big part of my article. I talk about Dred Scott and the particular problem, but that doesn't have as much to do with Chinese Americans. So I took that out. But it was an interesting problem. The problem was, and again, the problem was the problem was when slave owners took their slaves north or to free states. right? And the way it worked was a slave, and women too at the time, were sort of not legal persons, and so their domicile followed that of their slave owner. So when they went, and when they changed, when their masters went to free states or territories and brought their slaves with them, the northern states started saying that because you were in a free territory and because your domicile moved with your owner, you are now free, right? So that's sort of what created the problem that Dred Scott sought to answer. So that's a long way of saying that even if you look at Dred Scott, the concept of where you were at home was a big part of the puzzle, right?
You're talking about before the Emancipation Proclamation?
Yeah.
Before 1863?
Yeah, because Dred Scott was 1858.
Yeah.
All persons subject to the it doesn't say all parents.
That's right. That's what I was saying, right? Persons subject to the jurisdiction. It's just that basically the idea was that an infant, you sort of, if you understand subject to the jurisdiction as something like subject to the political jurisdiction thereof, the idea is that because an infant doesn't have independent political affiliation, that they assume the political affiliation of the parent, actually the father, because the mother didn't really matter back then.
Sir, it seems like there are a lot of Asian Americans, Latino Americans, feel that the current administration is proactive in enforcing their perception of immigration law. Just last week, several hundred Korean who were sent here to build a major factory, they were hauled in. There seems to have been a lack of regulation that was convenient for Hyundai to bring these people in, so they brought them in mostly as best they could. But it's created a lot of unrest or chagrin in Korea. How do you see the judiciary here helping to moderate the activities that are encouraged by Stephen Miller and others?
Is this working? Oh, now it's working. Yeah. I have two thoughts on that, right? So in California, there was litigation with respect to the use of the National Guard to help ICE enforce the immigration laws, right? And Judge Breyer, the younger brother of Justice Breyer, who's retired, issued a very thoughtful opinion in which he said there's something called the Posa Comitatus Act, and that's a statute that says you can't use the military for law enforcement, right? And so he said that I think this is a violation of that. Now this is how interesting history is, right? Because why do we have the Posa Comitatus Act? Because Southerners in the Confederate South were sick of the Union using military to help free blacks, right? And so, I mean, now it's the ideological polarities are shifted. So that's an instance where the courts have effectively said that you can't use military for immigration law enforcement. So that's a guardrail. The other question you ask about the Hyundai, I mean, and I've been talking with lawyers, Korean lawyers, in conversations about it ever since it happened. I mean, there's very little you can do, right? I mean, it's kind of like after 9/11 when they rounded up all of these people from Muslim countries, and then for visa violations, if they violated the visas, then they violated the visas. They have a right to do that. Like where the legal claims came in was when they sort of detained them under harsh conditions and interrogated them and tried to get information and all that, right? So we're hearing some news about being detained under harsh conditions and so forth, but they don't seem severe enough to ground legal claims, right? I mean, I don't have any sort of special intelligence or information or insight into it, but it doesn't sound like it was severe enough for you to try to make claims there, right? I mean, it could be that you could. Now, part of why the judge and I set up this center trying to educate people on these issues, because I think a lot of Asian Americans are saying, are they targeting, sort of this factory because they're Asians? And, the judge and I teach this case involving Filipino nurses. And what happened was the corrupt prosecutor in Long Island, the nurses had been brought over by one of these health management companies, and they were being subjected to extremely difficult working conditions. They consulted a lawyer. The lawyer said, okay, after your shift, don't put any of your patients at risk. Just leave. And this prosecutor in Suffolk County actually brought criminal charges against the lawyer and all the Filipino nurses for dereliction of duty, effectively, right? And that was troubling because it's like, yeah, if they had not been Asians, would you have seen this happen, right? And so, but it's really hard to conclude one way or the other in these types of situations, but it is somewhat troubling, right? Sorry.
Yeah, I think this executive order and the National Guard actions do raise the specter of, and also all the attacks on so-called DEI, raise the whole question about race discrimination. So I guess my question is this, since we're here at MoCA and you have a center. I worked many years ago. In 1986, we had the Immigration Reform and Control Act,
Right.
which was the first federal act to bring in the I-9 form, address this whole issue as we're addressing now, I guess. We didn't have a handle on, I guess, a comprehensive immigration policy, but there was an attempt. And in the effort to address the possibility of discrimination in the enforcement of the I-9, the Congress put into the bill this provision that the Congress could sunset the law. If they found there was widespread discrimination after each year, the GAO was given that mandate. Anyway, to make a long story short, New York City played a big role in saying that you can't just limit your assessment to a very narrow way of looking at widespread discrimination, which is a term. And we found after each of those 3 years, and it was in the GAO report, that the two main groups that were actually discriminated against in the implementation were, not surprisingly, Asian Americans and Latinos. Because they wouldn't even get to step 2, in terms of. So this is, in my mind, the larger question, which concerns us, I think, maybe less legal but more political in the sense, well, it's legal and political, but because of the whole history of anti-Asian and other kinds of discrimination. So,
I mean, Rocky, those are valid points. I'll just say, I don't know if many of you are aware, but like the Supreme Court is on board for saying, the Supreme Court has never said it's illegal to discriminate on the basis of race or national origin in immigration policies, right? In fact, the 1924 Act, the Quota Acts, technically the United States, in terms of the case law, they're old cases, but, they can actually do that, right? I'm not saying you could sort of develop arguments based on the relatives and so forth, but like part of it is we have case law that was developed at a time that is still extremely permissive of discrimination, believe it or not, right? It's hard to believe, but it's true, right? Now, obviously, unlike the 1890s, Asian Americans now have political voice. I don't know what the numbers are, and so
now that you're sort of in the political process, are you going to have these laws come through? But the reality is, the government has a lot of discretion in this space, right? I mean, and it's kind of the way the structure has been built. I mean, and like if the Chinese hadn't been there, if they had tried to start discriminating against white people, Irish American, like maybe our law would have been much more permissive, right? Right? I mean, as a historian, it's like, oh, isn't it interesting how even when the Asians win, like in Wong Kim Ark, it's not really they who won, right? I mean, they won the case, but it was like all the European immigrant kids who won, right? And the laws like Che Chun-ping and the plenary power of government, they were the Chinese. They upheld the Exclusion Acts. So it is. It's another example. Chiland versus Freeman, very important immigration case, 1877. That's the one that the Supreme Court says the states don't have. That basically it's the federal government that controls immigration, not the states. And that was back when California was extremely racist and had these like completely crazy discretionary laws. Now that precedent is limiting California, right? Where California has a much more pro-immigrant posture, but that's still the law. Chiland versus Freeman still gets cited in these cases, right?
But I guess one question that bring up,
Yeah.
I think is a greater understanding of the, this history does not ensure, plus the fact that we have an imbalance now in terms of the three branch.
Yeah.
But you do have these examples, which I think, I'm sure you teach on them, like in the Erie Act, so, I think people, particularly Asian Americans, but obviously other groups need to understand the whole value of resistance.
Yeah.
And I don't think that case and the resistance of the Chinese community back there and the reliance on Western lawyers actually to pass back the case, the Hong Kong case.
Yeah.
There are good lessons about political power through mass mobilization. And I frankly myself feel that a lot of people are just wondering where are we going with this kind of downward slide.
Yeah. No, I mean, the Chinese hired really good lawyers. I mean, they had a lot of wins. They put a lot of money into that. I think that's a problem now because there's not as much money going into the oppositional work. And that's because so many people feel intimidated by the administration because they hold grudges, and so it's a problem. You need to have really good lawyers to win these cases, right?
Last question?
Yeah.
So you were mentioning the Europeans one with Wong Kim Ark, right? You showed us that stat where it was mostly Europeans that were immigrants at the time. I guess what was their status at the time? And then why did the Supreme Court feel like, what problem did the Supreme Court feel like it solved? And then why did Wong Kim Ark last all the way up until now? And how come people haven't challenged it? Because it sounds like it's challenging.
Yeah. No, I mean, so all of those Europeans here, technically their children would not be citizens of the United States if Wong Kim Ark had gone the other way, correct? And the problem that introduced was you had a lot of European countries that were claiming them as their own nationals and doing things like putting them in their navy or prosecuting like a bunch of Irish Americans who gave money to the Irish independence cause, the Fenians, and and even though they were U.S. born Irish Americans, they were contributing to the cause, the British Crown would prosecute them for treason, right? And so you introduced a lot of these issues, and so that all went away, so to speak, by saying that you're actually a U.S. citizen. Yeah, in a sense, the U.S. is making a statement by saying all of these people are actually U.S. citizens. We're claiming them. Plus like once you have citizenship, like you're much more tied to the United States, right? And so these people, I mentioned the case of Lynch versus Clark, an Irishwoman. That's 1844. A lot of people went back, and they would stay in the United States, which was good for them because they need a labor force. That's another fascinating thing that I found out from doing research in 1868. they lost 2 million men. I mean, they needed labor. They needed labor, right? I mean, the country needed labor for the economy. They just didn't want Chinese labor, right? And so, I mean, the railroads wanted Chinese labor. It was the white laborers who didn't want the Chinese laborers there. So there's a sort of this complicated interplay there. So in a way, this safely secures a big pool of European migrants and deals with thorny problems of dual loyalty, and sort of plants them in the United States. You do the same for Chinese, but there's only like several thousand of Chinese, but there's like, millions of Europeans, right?
And so why did it last all the way until now? I mean,
Yeah.
still to the
Yeah, I mean, I think that because we've never had a political administration that's really willing to take it on, right? I mean, there was a book written by two law professors in '85 that sort of during the Reagan years when they talked about this, but I mean, that language is pretty clear, and if you say subject to the jurisdiction thereof, just means subject to the territorial jurisdiction, subject to the sovereign control, which is what Wong Kim Ark seems to say. That's a pretty strong position, and we even during the Reagan years when they started cracking down on some of this. I mean, you've got to remember that, and I grew up in the Reagan years. The Republicans, there were a lot of pro-immigration Republicans because they were like real capitalists and free market, and they believed that it wasn't just capital that needed movement. They thought labor, right? And so what's happened now is that the Republican Party has become just completely anti-immigration, right? I mean, you had a lot of Republicans during the Reagan years who wanted free immigration, and now you've got an administration that's actually has the political will to push the issue, right? And so I think that's why it's happening. Yeah.
You know, they, I see the purpose of vetting immigrants to make sure that you don't end up with pending or
Yeah. Yeah. No, I mean, I think that I had a former student who was a federal prosecutor in Del Rio, Texas. And I remember talking to him, and he's like, you won't believe this. We're having 10,000 people come across the border, right? And I feel like basically, I mean, this is just not sustainable, right? And so part of the problem is we've gone from one build the wall to the other end, and we've sort of lost the ability to pursue centrist policies on immigration, right? And so I mean, it's kind of symptomatic of what else is happening in the country on a range of issues. You've got to be on one side extreme or the other, and that's really happened in immigration, right? If the Biden administration had been honest and say like, look, we can't. I mean, if they had started at the beginning of the term where they ended up, which wasn't that far from where the Trump administration had been, I mean, would we be where we are now? I don't know. But like the Biden administration, their political economy and their political support couldn't do that, right? I mean, they had to have a pro-immigration policy, and so now we're at this crazy place where he passes